Today's webinar is being recorded and will be posted to the NAGPRA events page after the program concludes. You can find other webinars that we have conducted there, again, on the NAGPRA events page. For your information, we do have the chat turned off for today's webinar, but you may post questions in the Q&A. We also do not intend to take live questions, but you are welcome to put your questions in the Q&A, or if you are having a technical issue, you are welcome to email us at nagpra_info or in response to the invite to this meeting. Again, hello everyone. My name is Melanie O'Brien and I'm the manager of the National NAGPRA program. Welcome to today's webinar on the revised NAGPRA regulations. I have prepared a short presentation to share with you. And again, we welcome you to post questions using the Q&A function of Zoom, and we will do our best to respond to them. Today's presentation is going to focus on the regulations in Subpart C, in particular, the provisions on repatriation of human remains, associated funerary objects, unassociated funerary objects, sacred objects, and objects of cultural patrimony. The presentation that I've prepared today is similar to a presentation that I gave in November at the annual Repatriation conference that is hosted by the Association on American Indian Affairs. This, again, is a similar presentation in format and will include some specifics about the revised regulations. To start with, I've prepared some slides that look at the provisions for repatriation that are provided in the Act itself, and then followed by slides about how those are implemented through the regulations. Again, it's important to understand that these regulations are an interpretation and implementation of the Act itself. So everything that is in the regulations is rooted in the language of the Act itself, which is why I felt like this was a good way to present the information, starting with the Act and then looking at what the regulations include. So to get started, just again as an overview, we're looking here at NAGPRA, the law itself, which you can access directly through our website, or you can find in many other ways. It's codified at 25 USC 3001 is the first section, and the sections regarding repatriation of human remains and other cultural items is in sections 3003, 3004, and 3005. So I wanted to start with the inventory sections today, in particular, the sections related to repatriation of human remains and associated funerary objects in particular. If we have time during this session, I will also cover the sections for repatriation of other cultural items, but I wanted to prioritize the time here today to talk about both the law and the regulations for repatriation of Native American human remains and associated funerary objects. Again, you're welcome to post questions in the Q&A for today's session, and we will try to address them either as we go along or at a break in the presentation. So in looking at looking at the Act itself, I'd like to try to address The first question about what is required in an inventory of Native American human remains and associated funerary objects, in looking at the Act itself. There is a question already about copies of the slides, and absolutely these will be posted to our events page along with the recording for this session. But again, everything that you're going to see today is taken directly from the Act or the regulations itself. So your best source for this information are copies of the Act and copies of the regulations. Something that we recommend anyone engaged in NAGPRA have readily available to them is a copy of the Act and a copy of the regulations. So in looking at the Act, again, Section 3003 on inventory, you can see here that I have reordered the paragraphs a little bit to assist with sort of how you can read these regulations in a way that might make a little bit more sense. So in looking at the inventory sections, the answers to the questions that are on the right of the screen, and I'll read those for those of you who might be joining by telephone. The Act answers questions about what is an inventory, what's required in an inventory, when an inventory is required, the options for an inventory, including what is not required in the inventory. And again, these are all questions that the Act answers for us. And then what is required after an inventory. So I'm going to go through each of those questions and provide how the Act provides the answer. And then we'll come back to those same questions and looking at what the regulations say. So first, what is an inventory? An inventory, according to the language of the Act, again, you can find this in the Act itself, is a simple itemized list that summarizes the information possessed by the museum or federal agency. So you can find that in combination of two paragraphs in the Act in Section 3003, paragraph E and A. And again, that is what an inventory is under the Act. What is required in an inventory is to identify the geographical and cultural affiliation of the human remains and associated funerary objects, and to do so in consultation with tribal governments, Native Hawaiian organization officials, and traditional religious leaders. Again, these are answers to the questions that come from the Act itself. Where is there discretion in an inventory? Indian tribes and Native Hawaiian organizations may make requests for additional information or additional documentation, as stated in the Act, or for a summary of records, including inventories, catalogs, relevant studies, and other data. So the discretion in the inventory sections is what Indian tribes and NHOs may ask for in addition to the inventory that is required. When is an inventory required? An inventory was required 5 years after the passage of the Act. So again, November 16th, 1990. The inventory was required by 1995. There is an option in the Act itself for the Secretary of the Interior to extend the deadline for a museum to complete the inventory process. What is not required in an inventory? The Act is pretty direct about what is not required in this language here on the screen. The language in particular talks about that information that is needed for a limited purpose the limited purpose of determining geographic origin, cultural affiliation, or basic facts around acquisition and accession. The requirement for information in the inventory sections of the Act is clear that this does not mean and cannot be construed to authorize any new scientific studies or other means of acquiring or preserving additional scientific information. These parts of the Act are very important, especially as we talk about how the regulations are implementing the limitations of what an inventory requires. And then what is required after an inventory? The Act requires that 6 months after an inventory is complete, the museum or federal agency must notify the Indian tribes and identify the human remains and associated funerary objects, and identify those that are clearly identifiable as to tribal origin, and those that are not clearly identifiable but reasonably identifiable. And a copy of that notice is then sent to the Secretary of the Interior to publish in the Federal Register. So this is where we get the notice requirements under NAGPRA. And again, the Act requires those to be submitted 6 months after that 5-year deadline. In addition to publication of a notice, there are some additional requirements in the Act for after completion of an inventory. The requirements are to share information with lineal descendants, Indian tribes, and Native Hawaiian organizations to assist them in making requests for repatriation. So again, that same obligation we talked about before, that an Indian tribe may request information and a museum is obligated to provide it. In addition, there's a requirement to expeditiously return human remains or associated funerary objects upon request, and to consult on the place or manner of delivery following that repatriation or that return. There are 2 exceptions to expeditious repatriation that are provided in the Act. One of those exceptions is if the human remains are needed to complete a scientific study of major benefit to the United States. That is a delay of repatriation of 90 days. Or where there are competing requests for repatriation and a museum cannot determine the most appropriate requester. That again is a delay to the requirement for expeditious repatriation. So I know that this might seem like a lot. The last slide I have here about the Act itself is the discretion after an inventory is complete. The discretion here again is with Indian tribes and Native Hawaiian organizations, and they may request repatriation following the completion of an inventory. They can request a repatriation of those human remains and funerary objects that are culturally affiliated, or they may request repatriation for those that are not culturally affiliated by showing a preponderance of the evidence that they are culturally affiliated. So again, this is looking at the language of the Act, and specifically in Section 3003 for what is required in an inventory. I hope that as we've gone through this, you still have a lot of questions about what exactly does an inventory require. And that's because the Act doesn't necessarily give us all the information that you need to practically carry out this process. And it is the regulations that inform how to implement these requirements. So I wanted to now turn towards the regulations and to look at, again, Subpart C of the revised regulations on repatriation. And in particular, we're going to focus here on 10.10, which is the repatriation requirements for human remains and associated funerary objects. I do see that we're getting a lot of questions in the chat, which is wonderful. And I do really appreciate those of you who are supporting and providing answers to those questions. I do have a colleague with me, Lisa Koszalski, who will also be working to try to provide answers to questions or links where possible. And then again, we will definitely come back to some of these questions after we talk through the regulations. So again, all of this information can be found in the Act itself or in the regulations, but I will commit to sharing the slides. So what we have done in revising the regulations throughout the regulations, but in particular, I will highlight this change here, is to make the process for repatriation into a step-by-step process. So again, the requirements mirror those in the Act, expand and explain the requirements that are in the Act itself, but also try to provide it in clear, easy to follow steps. So the first step in repatriation of human remains and associated funerary objects is to compile a list of those human remains and funerary objects. This is the first step that's necessary to work towards the completion of an inventory. It's important to note that the itemized list itself is not the inventory. It is the first collection of information about the human remains and funerary objects in a collection, in a museum or federal agency collection. Now, for many museums and federal agencies, this has already been done. This was done in the 1990s as a part of the initial compliance efforts, was this effort to compile an itemized list. But it's important to look at what is required in the itemized list, and that is on the left side of the screen under the check mark indicates those things that are required. Things like the number of individuals, the number of associated funerary objects, geographical location, acquisition history, other information, and information about hazardous substances. That's what's required to be put into an itemized list. Now, there are things that are not required in the itemized list. The itemized list does not require a physical inspection of a holding or collection. It does not require research of any kind, nor study or analysis. There is no requirement in the regulations for rehousing or reboxing. And there's no requirement in the law or the regulations for drawing, photographing, or measuring as a part of the creation of this list. Now, where there is some discretion in how this list is created is under the question mark here. So it is up to a museum or a federal agency to decide how to organize its itemized list, what level of detail to include in that list, and how it will be formatted. I wanted to point out a clarification that we've made in the revised regulations that again is consistent with the Act in how the number of individuals must be identified in this itemized list. The identification of a number of individuals, so the number of individuals represented by the human remains, must be done in a reasonable manner. It must be based on information available, and no additional study or analysis is required to determine that number of individuals. If human remains are in a holding or collection, then the number of individuals is at least one. And that language comes directly, again, from the regulations, and is an explanation of how what the Act requires in providing an inventory of human remains. Okay, I see a number of questions here that I think is probably a good opportunity for me to try to address. A question asks, physical inspection is not required, but what if the number of individuals and objects in a collection is unknown, poorly documented, or otherwise likely to be inaccurate? It's a great question, and it's one we get all the time. Again, the requirement under the Act and the regulations is for you to use whatever documentation you do have, whatever information you have available to you. That is what you're supposed to use to complete this itemized list. There is no requirement for a physical inspection. There is no requirement to verify the documentation that you have, but you are required to use the documents that you have. This is often confusing or challenging to understand, and we appreciate that it is it can be challenging and may not coincide with some of professional practices, but this is important to recognize the requirements that Congress intended museums and federal agencies to apply here is not to provide an exact itemized list of every let me step back for a minute. The inventory requirement is not an accounting requirement. The itemized list requirement is not an accounting process. Rather, it is making information available. And as you see in the next steps, the next step here is to consult. And it is through the consultation process where a museum or federal agency, again, with tribes, might be able to decide how much more of an investigation is needed. So again, it's clear in the revised regulations that if human remains are present in a holding or collection, then the number of individuals is at least one. And that is sufficient to complete the itemized list and to move forward to consultation. Another question related to this is how to determine the number of individuals, or if there are hazardous substances, if a physical inspection is, I'm going to say, is not required. Again, just like what I answered before about the number of remains, the same answer is applies to hazardous substances. There is no requirement here for a museum or a federal agency to do any analysis to make a determination about individuals or about hazardous substances. The requirement is to provide information when it is known. So again, it's about finding the information that is available and putting that together in this itemized list. That is the requirement here. There was a question about what does it mean to identify in a reasonable manner. A reasonable manner means that you could take the information you have to any other reasonable person and they could come up with the same conclusion that you do. So reasonable means a reasonable standard that a reasonable person would apply. It's a pretty universally used concept in the legal setting, and I think it's important to remember that that's what's required here. That you make an effort that is reasonable, that would be considered reasonable, and that the conclusion or the answer that you come to in making that decision about how many individuals in particular is one that any reasonable person could make if they were in the same circumstances. I'm going to go ahead and leave these questions. Well, I'm going to go ahead and say that I've answered them live, so you should still be able to see them in the answered section, and you can still provide additional comments if you would like to. Okay, hopefully I'm going to try to keep up and keep moving here. But I encourage you to look, especially at the questions that I've answered live, because there are some additional comments from other participants there. Okay, so what happens after you prepare this itemized list? The next step is to provide that itemized list to tribes and Native Hawaiian organizations that might have an interest in those collections. So again, the requirements to initiate consultation are to share your itemized list with lineal descendants, Indian tribes, or Native Hawaiian organizations that have potential to be culturally affiliated. You share the itemized list as well as the names of any other parties that you've identified as potentially culturally affiliated. And in that initiation of consultation, you propose a timeline and a method for conducting consultation. That is what's required. Again, I think it's important to consider each of these steps in the broader process. And the National NAGPRA program has prepared a document called Steps to Repatriation, which lays out each of these steps and summarizes the requirements, all of the items that are under the check mark. Hopefully, we can find a way to post that Steps to Repatriation, but it is available through our website, and it's a good overview of each step. If you ever have questions about how to complete a step, I think it's always important to look ahead to what the next step is, so you can maybe better understand what the requirement is. And certainly the objective and requirement of that itemized list is to share that information with tribes through the second step, initiating consultation. What is not required in initiating consultation is to invite every single federally recognized tribe or all NHOs to consult. There is no requirement to conduct research to determine who to invite to consult. And I think it's very important to emphasize that there is no requirement to have a final or accurate inventory prepared before initiating consultation. Again, this is the first step of an itemized list. You could consider it to be a rough draft that you're sharing with the other parties involved in this through initiating consultation before you get to that final draft. Where a museum or federal agency has discretion in initiating consultation is how they distribute or who they distribute the invitation to, if there is a response deadline or a response method that the agency or museum would like to include in its initiation of consultation. Now, it's important to remember that this is only an invitation, and Indian tribes and Native Hawaiian organizations are not compelled to respond to this invitation. But if they do respond, then a museum or federal agency is obligated to consult. The obligations in step 3 of the process are to respond to any consulting party, to try to identify through consultation lineal descendants, Indian tribes or NHOs with cultural affiliation, as well as associated funerary objects. And there's an emphasis here on consultation to identify the proper duty of care for these human remains and associated funerary objects. And I'll speak more to that in a minute. Lastly, the last obligation here under step 3 is to make a record of consultation. Now, what is not required in step 3 for consultation, there's no requirement that consultation be conducted in person. Often that is the preference of consulting parties, but it is not a requirement. Again, there's no requirement to conduct a physical inspection during consultation. Again, it is often a preference. Sometimes it is a component of consultation, but it is not a requirement. Consultation doesn't have to occur multiple times. It doesn't require written transcripts be produced of the consultation. And for purposes of NAGPRA, consultation does not require decision makers to be present. Now, there may be other authorities that your museum or your federal agency has that govern how consultation is conducted. And in those cases, then decision makers may need to be present, but it's not a requirement under NAGPRA. And certainly, just like physical inspection and in-person, it may be the preference of the Indian tribes or NHOs involved that decision makers are present. Lastly, there's no requirement during consultation for Indian tribes or NHOs to disclose any information that is sensitive. Where there is discretion or some decisions that can be made by museums and federal agencies, as well as all the consulting parties, are what is the timeline for consultation, what are the methods for consultation, and then who is going to provide the financial support that may be necessary, especially if consultation is conducted in person. All right. Yeah, I'm going to go ahead and answer a question about this question of financial support. Who is responsible for funding the travel or bringing groups to inspect a collection if it is the preference? That is up to the parties to figure out, really, and to resolve. There are NAGPRA grants that are available on an annual basis to support consultation in particular. So that is one option. But the Act itself doesn't give, the Act or the regulations doesn't say who is responsible for financial support. And it should certainly be a part of the conversation around what the timeline and method for consultation will be, because obviously finances will have an impact on that and funding. All right. If consultation is a requirement, but the federally recognized tribe doesn't accept the invitation to consult, how should a museum proceed to fulfill the consultation requirements? That's a great question, and one that we tried to address in the final rule, and actually has been addressed in these regulations since they were first issued in 1993 and 1995. So for human remains and associated funerary objects, there are timelines to complete an inventory, which is the next step. And those timelines are triggered and must be met whether a tribe responds to an invitation to consult or not. So where a museum initiates consultation, it should make a record of that effort to consult. A museum or federal agency should certainly make a record of any attempts it makes to contact tribes and to initiate and engage in consultation. But again, it is not required for Indian tribes or Native Hawaiian organizations to respond to that request. So you could be in a situation where an Indian tribe does not respond and consultation does not occur. But the museum or federal agency must still meet the deadline for completing an inventory and making determinations in the inventory. So hopefully that answers the question. A question if I can define who consulting parties need to be. The regulations provide a definition for consulting parties. Under initiate consultation, it says consulting parties are any lineal descendant and any Indian tribe or Native Hawaiian organization with potential cultural affiliation. So again, consulting parties are those that can be identified based on the information you have. And if that information shows that there are lineal descendants or potential culturally affiliated parties, that is who should be invited to consult. Another question about consultation, actually about the invitation to consult or initiate consultation in step 2, do we have to reach out to consult via mail or email? Is there a standard for inviting? The only requirements in the regulation are that the invitation to consult be in writing, but in writing can mean by email. There are provisions in the revised regulations under 10.1 to assist with how documents are delivered. And documents can be delivered by email with proof of receipt. So some way of knowing that the email was received, or proof of delivery. It can be automated, or it can be a follow-up phone call, or you can deliver invitations to consult or other written documents by physical mail, physical delivery. How many grants are there for NAGPRA, and is it only through the federal government, or do states also have their own grants, is a question. So we provide a grant program through the National NAGPRA program through the federal government that you can apply for on an annual basis for consultation. And I am not aware of other grant opportunities, but maybe others in this group might have some ideas for you. Okay, I'm going to go on to step 4, and then I'll come back and try to identify questions to answer. I do want to note that you can upvote questions by liking them, and that will raise it to the top of my screen. So if there's a question asked in the Q&A that you also have, you can support that, and we'll try to address those in that order. But moving ahead to step 4, completing an inventory. So again, the first step, itemized list. The second and third step are consultation related. The fourth step is when you complete the inventory. A completed inventory must include consultation information. It must include that itemized list, but again, updated as necessary. And then the key to the completed inventory is to include determinations of either lineal descendants or cultural affiliation. And if there is no cultural affiliation, then the inventory must explain why. What is not required in an inventory is any kind of cultural affiliation record or justification beyond that explanation if no cultural affiliation has been determined. There are no requirement to share details of what was shared during consultation, and there is no obligation to include sensitive information of any kind. Again, it's important that there be information that consultation was conducted, but not the specific information that was provided during consultation. Again, museums and federal agencies have an opportunity to determine how they will organize the contents of the inventory, just as they did with the itemized list, what level of detail is included, and then of course the format of that. There's a related question, I think, from earlier about whether age at death or sex should be reported in an inventory or an itemized list. And it's certainly not a requirement. There's no requirement for that specific information to be shared in an itemized list or in an inventory. It should certainly be the subject of consultation to determine if that is information that the tribes involved would like to have included in the inventory process. Okay, so part of what I wanted to be sure we discuss is is the timeline for completing these steps, and we'll get to that in a minute. Actually, I'm going to jump ahead to that because I think it's important as we talk through steps 1 through 4 that we talk about the required timelines. This is an image from, again, the Steps to Repatriation document that is available on the National NAGPRA program website. And it gives a hypothetical timelines for completing steps 1 through 8. So far, we've talked about steps 1 through 4. And I want to emphasize that there is a deadline for completing step 4, the completion of an inventory. And Congress, again, provided 5 years for an inventory to be complete between 1990 and 1995. In the proposed regulations to revise a NAGPRA that were issued in October of 22, we proposed a 2-year timeline to update inventories. So a 2-year timeline to redo those inventories or to update past inventories that had not been published in notices. I wanted to emphasize that the final rule allows for 5 years for these updates to be completed. So where a museum or federal agency reported Native American human remains and associated funerary objects in an inventory, but has not completed a notice of inventory completion, there is an obligation under the final rule to update that inventory and to complete the update through step 4 within 5 years of the final rule. So by January of 2029, there's a requirement to complete steps 1 through 4, although again, really step 1 is the itemized list that presumably has been prepared, or at least prepared based on available information. So the obligation is for museums and federal agencies to initiate consultation, conduct consultation when requested, and to complete that inventory within 5 years. So this goes back a little bit to the questions about what to do if there is no response to an invitation to consult. There's still an obligation to move forward and to complete the inventory. And again, the recommendation is to ensure that you're making a clear record of your efforts to engage in consultation, but that you've received no response. So again, I realize that it might feel like a long time ago that we talked through the basics of the act itself, but this is all related, and I hope that you can see that connection. Because again, after completing an inventory, the requirement is to submit a notice, just as it is in the act, and to submit that notice for publication in the Federal Register. The information that's required in step 5, submission of a notice, is again the information and the determination that's made in the inventory itself. The number of individuals and funerary objects, associated funerary objects involved. Contact information for the museum or federal agency is necessary in a notice, as well as a date that's calculated in the publication itself for when repatriation can occur. Notices require a 30-day period for any additional requests for repatriation to come forward. Now, there are things that we typically see in a notice or in an inventory for that matter that are not required, and I wanted to point these out. Things like site numbers, accession numbers, and then as we discussed in response to the question, age, sex, or other detailed information about the human remains is not a requirement for an inventory or a notice. Now, that doesn't mean that it can't be included, but I want to be very clear, it's not required. And when it is included, that conversation about whether to include it or not, whether to even identify that information or not, should be a part of the consultation process that precedes both the inventory and the notice. Again, there's an opportunity for museums and federal agencies, along with their consulting parties, to decide what the organization of the notice will be and what level of detail to include. So it is getting to this publication of a notice that provides the opportunity then for Indian tribes or Native Hawaiian organizations to make requests for repatriation of those human remains. So step 6 in the repatriation of human remains and associated funerary objects is receiving and considering requests. Joint requests may be received, and they should be considered to be a single request, not competing requests. And a requester can be Indian tribe or NHO identified in the notice, or it could be an Indian tribe or NHO that shows that they are culturally affiliated by providing a preponderance of evidence. Additional information from a requester, if they're in the notice, is not required. So where an Indian tribe is identified in a notice, there's no additional information that's required in their request for repatriation. Now, where an Indian tribe is making a request and they are not identified in a notice, then additional information to support their request and certainly the preponderance of evidence request would be necessary. But there's no additional information needed at the time of a request from a requester. The obligations or the opportunities for museums and federal agencies to determine how they will proceed is to think about how museums and federal agencies will manage and track these requests and what their own internal protocols are for considering these requests. I should have said at the beginning, and I should emphasize again here, that both the Act and the regulations are written with the museum or federal agency as the actor or as the subject. And that is quite intentional because the obligations for taking action in both the Act and the regulations is on the museum or federal agency. While there are plenty of opportunities for Indian tribes and Native Hawaiian organizations to take action under these regulations, none of that action is required. So when we're talking about these steps and who has to do them, I want to be very clear that it is intentionally oriented towards the requirements for museums and federal agencies. So once a museum or federal agency receives that request for repatriation, they must then respond. And there is a timeline for responding. There are some specific responses that can be provided after receiving a request for repatriation. And it can be one of the following: that the request meets the criteria and repatriation will proceed, or the request does not meet the criteria. In that case, the museum must request additional information from the requester. Or a third option is that there have been competing requests that have been received, and the museum or federal agency must evaluate those competing requests. What is not included in the regulations, but something that is often a part of the process, and you should be aware that it's not a requirement. There is no requirement for an internal committee or a board approval of a request for repatriation. Certainly that can be the part of an internal policy, but it's not a requirement of the regulations. There is no legal review that's required of these requests for repatriation or of the decision of the museum. But again, it could be internal policy to take those steps. And there's no requirement to evaluate additional information, but rather to take the information from the request and what has been provided and gathered already through the inventory process to make the decision here. Again, I point this out because I think that it's a key opportunity to think about how the practice of repatriation over the last 30 years might be different from these specific requirements in the regulations. Again, I will just stress that there still is a timeline. So where a museum may decide to add its own policy or procedures involving legal review or approvals of a certain level, that all must be done within the timeframes provided in the regulations for a response, which is which is 90 days after a request. We'll get to that in the timeline in a minute. The last step is to send a written request to send a written repatriation statement. A statement gets sent to the requester, as well as a copy to my office, the National NAGPRA program. And it is only after that statement is sent that a museum or a federal agency would have requirements to document physical transfer as well as to protect information. But it is the process of sending that conveys the object to the requester and completes the process. There's no obligation in the repatriation step for any additional negotiation or any additional verification of the collection or the information involved. There are some opportunities for other agreements that might be made between the parties following repatriation, and physical transfer can or may occur depending on the agreement of the parties to when and how that would be conducted. So again, we've provided in our steps to repatriation document an example of a shorter time frame for this process, as well as a longer time frame for this process. We've provided here a 2-year timeline for the longer timeline, and that relates to the requirements for a new acquisition or a new collection and its requirements to complete the inventory within 2 years. This could be extended to 5 years in the case of updates to an inventory. But you can see that there's a lot of flexibility here in how long a museum or federal agency might take to complete each step. Certainly prior to the requirements under step 4, the deadlines that are required in step 4 to complete an inventory, there's flexibility in the timeline required for compiling an itemized list. There is a lot of flexibility for the timeline for consultation, but that all must be done before the required deadlines for step 4. Step 5 is required 6 months, no later than 6 months after completion of an inventory. Publication of a notice is again somewhat flexible, although there is a requirement for my office to proceed with publication of a notice that meets the requirements. So it is at maximum 26 days after submission that a notice would be published. It might be a little longer depending on weekends involved there in the Federal Register publication. Then after that, there are additional timelines attached to the process once a request is received, although a request for repatriation could be submitted at any time. I'm going to skip ahead a little bit here. Again, these slides just work through some of the deadlines. I'm going to keep my slide here, and I'm going to take a look at some of the upvoted questions and see if we can't address some of them. Just give me a minute. See where we are. Okay, there's a question and a comment. We have a large number of unreported ancestors and objects that were either missed or discovered since 1992 when we submitted our inventory. I understand we need to report these within 5 years. I'm not clear, do we have to consult on all of these objects, ancestors as we go? We are also receiving additional individuals as we speak who have been kept in another agency for years. How do we go? Do these go in a separate inventory? And is that the 2-year deadline? It's a great question. It's a little bit, it's a lot to kind of pull out and sort through. If you have collections that have never been reported in an inventory, then those are required to be submitted in an inventory 2 years after you acquire them or locate them or come to know of their existence. So there's a 2-year timeline for reporting on new or newly discovered collections. And that has been a timeline in these regulations for a long time. Initially, there wasn't clear guidance on what to do after the 1995 deadline, but since at least 2007, there has been a 2-year timeline for new or unreported collections. So yes, you would need to move to report those in an inventory. And yes, consultation must occur before that 2-year timeline is complete. So again, consultation is required to complete an inventory, and you would need to work consultation into that process of reporting. Now, how do you separate or how do you organize these ancestors and funerary objects? Again, I want to stress that this is only related. These timelines that we're talking about and these steps are only related to human remains and associated funerary objects. So for human remains and associated funerary objects, there's a 2-year deadline. And how you organize your work within that 2-year time frame, you may, depending on the workload, need to proceed in different projects over different times, depending on when you learn about the collection. So for example, if you have things that are coming in now, the 2-year timeline starts now, as opposed to collections that you might have found previously. You have a 2-year timeline from when you knew about the collections. So I hope that answers the question that was asked. Of course, we are available to assist directly on questions or issues if you find that you would like our assistance. I will note for everybody in attendance, and I think there are over 600 people here today, we have had a huge influx, obviously, of questions, and we are working as quickly as we can to answer them all. So please be patient if you do send us a question by email or phone call, and we'll get back to you as soon as possible. What if an organization has many objects that have little to no information, making it hard to complete an inventory and identify the geographical or cultural affiliation? It's a good question. What your obligation is to use the information that you have. And where you have little or no information about the objects themselves, you do have information about your organization, whether that is your own internal history about how the collection was founded or where it's housed today. That is information that can be used to help you identify and consult with potential consulting parties, potentially culturally affiliated parties. Anything, even just where you are located yourself, gives you a place to start. And that's what we would say you should start with, the information you have to initiate that consultation. A follow-up to that was, how do you treat objects that have no provenience? If you can't do research, a very large number of our vessels have no known provenience information. So again, we're talking here only about human remains and associated funerary objects. But in those cases with human remains and associated funerary objects, you take the information you have. And I want to stress that that information could be provenience information, meaning where the object was removed, but it can also be provenance information, meaning where the object is currently, or its acquisition history, its history of how it came to be in the museum. All of those are important. Those are both important pieces of the information that contribute to the itemized list for human remains and associated funerary objects, and then how you identify consulting parties. And again, this is very specifically addressed in the regulations themselves, and I would encourage you to look at the language there. There's a follow-up question about grants that I see someone else has answered, and I appreciate the assistance there. And we do, again, have grants that are available for assisting with the consultation piece of these processes. Okay, we are at the top of the hour. We have about 30 minutes left in today's scheduled webinar. A question that I'd like to share with everyone. We, the tribe I work for, are requesting that faunal remains be examined to determine if human remains were mislabeled. When human remains are identified at that stage, what would the next step be? Whenever human remains are identified in a collection, they would need to start with step 1 in compiling that itemized list, and then inviting consultation on that collection. I will say that in the case of faunal collections where there may be human remains present, those faunal collections can be a part of consultation on other pieces, other collection, part of that collection. So if faunal remains are a discrete piece of a larger collection that includes human remains and associated funerary objects, consulting on all of that at the same time can help alleviate some of the issues that the question identified in starting over. And again, where human remains are present, even in commingled collections, those should be treated as human remains. And at least for the purposes of step 1, in compiling an itemized list, they should be included in that itemized list. And then through the process of consultation, determine whether or not the tribes who are consulting wish to have additional analysis done of those collections to separate out the faunal collections and the human remains. Okay, I'm going to try to resort this. Okay, so it looks like we had an early question that received a lot of upvotes on the types of cultural items involved in NAGPRA, and we didn't really talk about that. So I'll take this opportunity to switch gears a little bit and to mention the other section of the Act and the regulations that we haven't talked about today, and that I don't think we're going to have time to go through. But we'll hopefully make a subject of a following webinar. And that is the unassociated funerary objects, sacred objects, and objects of cultural patrimony. Those are the types of objects that would fall under the repatriation provisions in the Act and the regulations for a summary. This is different than the itemized list and the inventory that we were just talking about for human remains and associated funerary objects. The question is about the definitions for those objects and what meets those objects. The answer, which somebody else provided, but I will agree is accurate, which is that the definitions of those objects under NAGPRA varies greatly, depending on which Indian tribe or Native Hawaiian organization you are consulting with. And that is why the process for a summary under NAGPRA is a general description of a collection and then sharing that general description with Indian tribes and NHOs for further consultation. It is through the consultation process that the identity of those objects could be made. Again, information is necessary from tribes and NHOs to assist with making those identifications. So I agree with the response. The best bet is to include everything that might potentially be one of these kinds of objects in a summary, and to provide that summary to Indian tribes and Native Hawaiian organizations. All right. There are quite a number of questions related to the requirements for duty of care. This is a provision of the regulations that I don't have a prepared slide for. They fall, although the duty of care is a part of consultation in both of the repatriation sections, as well as other sections in the regulations. You can find the provisions for duty of care in the new regulations under 10.1 paragraph D. I will add that the National NAGPRA program has provided some additional guidance as well as some frequently asked questions for the duty of care requirements to assist you with understanding those requirements and what is needed. The questions in the chat are about how to obtain the consent. That is one piece of the duty of care requirement. The regulations don't specify how that consent is received or how it is recorded, although it is, again, I want to stress that duty of care is a part of the consultation process and should certainly be a part of the record of consultation that's made throughout either the inventory or summary process for repatriation. I will leave it there with that question. There are a lot of questions about the duty of care requirements, and I will say that the best answer that I can give to any question you have about how you're caring for objects as a museum or a federal agency is to first look at your record of consultation on those specific objects or that specific collection. That's the first place to start. And if you don't have a clear record of consultation, then moving towards consultation on those collections through the inventory or summary process or independent of those processes is your best place to start. All right. I would invite you to add additional questions. Related to duty of care, there's a question about whether grant applications from tribes or museums to carry out the duty of care requirements will be considered for funding. Again, consultation and documentation grants provide broad types of projects, and the duty of care requirements, again, are a part of the consultation requirements under both section 10.9 and 10.10 on repatriation. So I would stress that as a part of that, certainly those duty of care requirements are included in a consultation or documentation project. And I would encourage anyone who has questions about a specific grant application to reach out to the National NAGPRA program. We'd be happy to assist. And I will note for everybody that there are only a few weeks left before the consultation and documentation grants are due for this fiscal year. Those are due on March 8th. A question about how to handle the display of funerary objects if Indian tribes do not respond to an invitation to consult, or any objects for that matter. Again, it's important where a museum can look to its own records about what items it has and what consultation has occurred on those items. In the case of a funerary object, if it is clear to the museum from the museum's record that these are funerary objects, then there is an obligation to ensure that consultation is conducted prior to the display of those objects. It becomes a question, certainly for any museum, to look to its own record and what it knows about its collections and the objects in question in determining what its obligations are under the duty of care requirements. So I'm going to stress again that the important piece here is to have information that is available to you, and to understand what information you know about an object, and then to be sure that you are reaching out to potential tribes to consult on those objects for additional information. Okay, if geographical origin is unknown, and there's no information relating to how human remains were exhumed, how should a museum identify tribes to consult? I'm thinking of medical supply companies that sold remains to university, and now the university is responsible for NAGPRA compliance. It's a good question, and one that we get fairly frequently. I would remind all of you that the first requirement under NAGPRA is whether or not the human remains are Native American. And that's the first decision that a museum needs to make about the human remains in its collection or in its care. And that would include a university and any human remains that might have been acquired through a medical supply company, as to first determine that those human remains are Native American. Only when that decision has been made does then NAGPRA apply, and do the questions that you're asking need to be considered. And again, where there's no information about geographic origin, but the human remains are Native American, are determined to be Native American, then you would proceed with what you do know, which is where they are now located, to identify consulting parties, and to hope that that information will lead you to, if not additional consulting parties, to the necessary determinations for cultural affiliation, or that no cultural affiliation could be determined. Okay, there's a great question about the list of tribes that are federally recognized after 1990. Yes, the list that we provide, the annual list that's produced by the Bureau of Indian Affairs and the Department of the Interior, is a full list. It doesn't say when each was recognized. And again, the obligation is now that any Indian tribe that is on the list of federally recognized tribes are those that should be consulted under NAGPRA. Okay, I'm going to resort, see if there are additional questions that are rising to the top here. We've been able to answer quite a few of the questions, which is great. As a question, going back to the requirements for identification, even in step 1 of the number of individuals, the question is, doesn't the law say that museums and federal agencies must complete an item-by-item inventory of human remains and associated funerary objects owned or possessed by them? How do we do this if we can't do a physical inspection and if no documentation or existing catalogs exist? What do we base our inventory on? It's a good question. So again, I want to stress that where there is information available, that is the information that is needed to compile the itemized list. If your collection consists of boxes or containers and no other information, there's no other documentation about what those containers hold or contain, then obviously you have some obligation to figure out what is inside the containers. But again, I want to stress that where you have information, even if the information is what is written on the container, that is information that you need to consider and that can be used to compile the itemized list. Now, again, the responsibilities here are to proceed in a reasonable manner, to do what is necessary to identify human remains and funerary objects in your collections. And the hope would be that you have at least some information about what is in the containers that you have. But if you really have absolutely no information about the containers that are housed in your facility, you have an obligation to figure out if those containers have Native American human remains or associated funerary objects. And that's how you proceed with your inventory. Excuse me, that's how you proceed with your itemized list. I will say that one option in this circumstance is to identify those containers that have human remains. And in those cases, put them on the list, the itemized list, and not do any additional review or analysis until that consultation can be done. There's obviously an obligation for a museum to identify what containers have human remains and associated funerary objects and to provide that information to tribes. But it is important that that next step be undertaken to consult on what additional analysis might be needed of what is in those containers. There's a question on competing requests for repatriation and who makes the decision. And what if a decision cannot be made and multiple tribal nations have equally claiming rights? The regulations provide a process for museums and federal agencies who make the decisions to try to identify a most appropriate requester. Again, this is at the end of the process. I want to stress that this does not come up until in step 6 or before step 8, there are multiple competing requests. In that circumstance, the museum or federal agency has procedures that are provided in the revised regulations to evaluate and try to identify a most appropriate requester. There is also guidance on for cultural affiliation, who is the closest culturally affiliated tribe, which is how that identification could be made. In the case where a museum or federal agency cannot identify the most appropriate requester, then they would then inform all the parties that that is the case. So again, there are specific procedures provided in the revised regulations to assist with that. And hopefully that answers your question. All right. Another question here: as a tribal representative, I often have museums send me transfer paperwork that places additional requirements on the return of ancestors and cultural items. This is after a notice has been published, the tribe has placed a claim or request, and the 90-day timeline has expired with no competing requests or claims. For example, transfer paperwork requiring inventory verification, indemnification, waivers, etc. If we just want the museum to return those ancestors without agreeing to everything extra, how do we do that? It's a good question. We're certainly aware of additional stipulations or requirements attached to a repatriation statement, what was previously called a transfer of control. We have provided a template for a repatriation statement. And again, this is a document that a museum would provide to a tribe to complete step 8 for repatriation of human remains and associated funerary objects. There is no requirement for a tribe to countersign transfer paperwork or a repatriation statement. Again, in following the step-by-step process where the tribe has made a request under step 6, the museum is obligated to respond under step 7. And in this circumstance, as it's laid out, that's what I would look to be sure that the museum or federal agency has provided a written response to that request, agreeing to the repatriation. That is the back and forth that's necessary under the revised regulations to then proceed to that step 8, where the repatriation statement is issued. We did try to address this in the final regulations, and I'm sorry I can't call to mind which question exactly it is, or I'm sorry, which comment and response, but there is some additional guidance provided there on stating very clearly that there are no additional requirements that a museum or federal agency can impose on the repatriation statement process. That in the repatriation statement, the transfer, at least the legal transfer, the recognition of the conclusion of the process is all that's required there. There are some responses provided from other tribal representatives about how they handled this circumstance. And yes, I would definitely encourage you to look for related comments and responses in the final rule that might assist you with making your response to those kinds of situations. Again, it's our hope that the regulations simplify this process and will make it clearer for everybody involved about what happens and what the next step is. There were some questions about the California state law, NAGPRA, and how it connects to the federal requirements. And I will say that we do have again, a guidance document on our website related to this, but I agree with the response that there isn't necessarily a conflict here. There are two processes, and there is a clear requirement in the California state law for the completion of the federal legal process. But again, we've provided additional guidance. I think that the California State Office, the Native American Heritage Commission, is also provided guidance and can be available to assist with specifics. Great. There was another response here that there is additional funding opportunities available through the Association of Tribal Archives, Libraries, and Museums, and in particular the Going Home Fund, that might be able to support some pieces of repatriation that are not necessarily NAGPRA related. a question about going over the step-by-step process for cultural items. And while that was definitely my intent today, it was not realized. So I will look to the next monthly webinar in March to address the step-by-step process for repatriation of cultural items. Today's focus was on the repatriation of human remains and associated funerary objects. Question about how to identify those tribes that are interested in consulting on a specific geographic area. There was a suggestion for 2 resources that are available. Question about whether there are additional resources available. We do thank you for providing consultation resources that are available on our website, as well as additional resources. I would say that a good resource for identifying tribes with an interest in a geographic region are previously published notices under NAGPRA. You can search the Federal Register for specific county and state, and generally you can find other notices that might be from a similar location or area, and that will at least give you an idea of who someone else consulted with. It's not an you're not obligated to make those same decisions or same consultation, but it's a good place to start. But I would add to all of that, the best the best resource for where tribes have an interest in what geographic region is the tribes themselves. I think that any place you start with consultation can be a good place to find out more information and to proceed from there. I'm gonna, it's probably gonna take me longer than we have left to go over to try to figure out what some of these questions are. So I'm gonna stop sharing for a moment. And again, I'm going to thank all of you for attending today's webinar, and I especially appreciate the questions that were asked. I realized that there are a lot more questions than I was able to get to today. I really appreciate the additional support from those of you who were able to provide some answers as we went along. We will try to identify additional questions and provide additional guidance through our frequently asked questions. We have provided some documents through our website again, and we are working as quickly as we can on other documents that we will be able to provide to you to help address these questions. So thank you again for your time and your attention today. Please join us next month, again on the 3rd Friday, for what will be the second half of this presentation, and a look at the step-by-step process for repatriation of cultural items. Thank you again.